Thanks so much for attending. We really appreciate you signing up for the overview. Um, we were going to do a book tour, obviously, in light of the circumstances, we have to do a virtual book tour. As a thank you for everyone who's attending, please send me an email if you have the chance with your contact information, and we will send you a free book. It's our pleasure. We really appreciate you attending. I've also invited Brian Page um, at our firm. I like Wade Brian, who is a total guru at estate and gift compliance, and really we work kind of hand in glove on a lot of the international tax issues on the foreign trust, etc. I'm sure he'll have some great pearls of wisdom. Um, we wanted to say hello, and then we're going to turn off the camera so you guys can see the slides right here. This is the extent of my technical ability. And then we can start the presentation. We're going to do this really as an overview. It's really a discussion. Please chime in. There's a question and raise your hand part of the slides. If you have a question, you can send it in. You can also, obviously you can email us or call us at any time. And at the end of the presentation, we'll give you our email and contact information. So I guess we can get started. It's an overview, so we wanted to give you the agenda. The agenda hits more or less, it hits the chapters of the book, which covers estate and gift for the non-citizen. So when we talk about the non-citizen, we mean both. The book covers both non-citizens living in the U.S., so non-citizen residents, and non-citizens living outside the U.S., with no contact with the U.S. except potentially having assets in the U.S. Both are handled in very different ways. We're going to go through some of the issues that arise. Each of these topics basically you could do an entire seminar on each of these topics. So what we want to do, we have a lot of CPAs on the line, a lot of tax professionals, is we want to kind of raise some of the traps and issues that you'll come across in your practice, so that at least you can identify some of the major sources of IRS compliance matters and planning that we see day to day. So that's kind of number one, the introduction. We're going to go through the estate and gift tax from a generalized perspective. We're going to determine, are you in the net? Are you in the estate tax net as a non-citizen? We're going to talk about exactly how the estate and gift is imposed on U.S. citizens and resident non-citizens. There's a lot of similarity there. In other words, once you become a resident, it's very similar to being a citizen for estate tax and gift tax purposes, but it's not the same. So it's fairly complex. And then, one of the major pieces associated with being a non-citizen resident are spousal transfers. It's very liberalized if you have two U.S. citizens that are spouses, in terms of waiting to the second to die, let's say. So that nothing in general is going to happen until the second spouse dies, provided all the assets go from one spouse to the other. That's not true of non-citizens, even if they live here. So we'll hit that. And then we go into lifetime gifts, which is also limited for non-citizens, even if the non-citizen is a resident of the U.S. And that's estate and gift. And then we'll go into some means of avoiding taxation entirely through certain asset considerations, and we'll go into treaties, how that works from an estate and gift tax side. A lot of treaties cover income tax, but we're going to cover mostly estate and gift tax today. We're going to determine how assets can be shifted from a U.S. site as taxable assets to a non-taxable asset. how enforcement works under agreements with other countries. And then to the extent we have time, we're going to go into foreign trust, pre-immigration planning, and expatriation. So we're going to talk about how monies are moved out to foreign trust by US people, how monies are moved out by non-US people before they come in. That's pre-immigration planning and trust, and then expatriation, which is its own disaster, and how that expatriation not only applies to U.S. citizens, but it also applies to people who are not U.S. citizens living here for a long time. So these are some of the relevant estate and gift issues. Tony was nice enough to slide my book in there. And so we'll start with the overview. Basically, U.S. residents and citizens are subject to estate and gift tax on all their assets. So, for instance, we had someone come in last week on an income tax issue, and they didn't realize that they happened to be from, I don't want to say the country, let's just make up a country, let's say they're from Peru. And they're in the office, and they've started a business in the U.S., and so we need to do some planning with respect to the business. And they've moved here, maybe permanently, but they really kind of intend to stay. So if you move here and you intend to stay, even though you're not a citizen, you become subject to worldwide U.S. estate taxation. So this person. And we find this the most shocking is to the individuals who are not citizens come in, they come in and they may stay, they're probably going to stay. They don't realize that they've now subjected everything that they have to the U.S. estate tax. and that becomes a huge problem with respect to people who most of their stuff is not here. So there's a lot of planning that has to be done with respect to those people. Another interesting issue is, so they can't be U.S. residents, or we have to do some planning with respect to the fact that all of the U.S. assets they acquire, we've got to make them non-U.S. assets. An interesting contradictory issue has come up recently on a couple of clients where they didn't do planning. We're finding them after the fact. The CPAs can tell you that never happens. Like, everyone plans. Actually, we find, what do you think, Brian? Maybe 5%?
If that.
If we really do planning before they come.
Actual planning.
Yeah, where they move stuff out of the estate and gift tax net. Sometimes you find people like this, and it sounds kind of odd, but a lot of these people have invested most of their money, even though they're not from here and they may have large businesses elsewhere, in the U.S. So it's U.S. property is what they have. And in light of the fact that non-residents don't get the exemption, the estate and gift tax exemption that residents get, sometimes it's actually a good idea to become a U.S. resident and subject all of your assets to the U.S. estate and gift tax because of the current very, very large estate and gift tax exemption. For husband and wife, it's about $23 million. So depending on the facts and circumstances, the planning really varies. It really has to do with exactly what's going on, how much they have, where they have it. Do they want to stay here? Do they have kids here? Are they at a point where they can actually do trust planning, transfers, etc.? It's very factually based. The second point, they're non-resident, non-citizens are subject to U.S. estate and gift only on the assets located in the U.S., right? So what we want to do, if you're not going to come here permanently, what we want to do for sure is we don't want to have U.S. Situs assets because you're going to be subject to the estate and gift tax, the U.S. estate and gift tax, and you don't even live here and you're not a citizen. So what we want to do is we want to create a structure whereby you can invest in the U.S., practically speaking, but you don't create any U.S. Situs assets. Yes, that's very possible. We do this all the time. Another point here, which we added to this slide because we don't want to miss it, is that a lot of times people don't realize that the gift tax and the estate tax, which are, subject to this unified credit, if you're a U.S. person, you get a very large unified credit, you can give things away, you can die with them, and to the extent you're under the $11.5 million, there's no estate gift tax. People who are not resident, not citizen, don't get that. They get a very small $60,000 exemption. But what they do get is an odd legislative piece whereby a non-U.S. person can give away intangible property with no U.S. gift tax. So you can limit, even if you've made the mistake by coming in and investing without proper structuring, if you can give away intangible property, you can often limit estate. There's no gift tax, and then you can limit the estate. So Brian, what happens when you die with it?
Oh, then which we've seen
a number of times.
Then the family of the client is shocked to know they only get a $60,000 exemption
on death.
On death,
right? So the gift is segregated. I don't know how this happened legislatively, but it's a huge opportunity for people, non-U.S. Citizens living abroad. You can move intangible assets at no gift tax. It's something that we just didn't want to pass by in the introductory pieces here. So in general, the third point, to avoid worldwide estate and gift taxation, you have to typically minimize the time spent in the U.S. and make clear your intentions to return home, which we're going to hit, I think, in 2 slides. The next slide's an overview, what we talked about, of the $13 million husband and wife exemption. If you're a U.S. person, that's if you're a U.S. citizen or a resident for estate tax purposes. And even non-citizens and foreign people get the $15,000 annual gift exemption. So you give away $15,000 in U.S. assets to anyone you like, and there is no gift tax. And the rate, most of the practitioners listening are aware of the rate, but we always state the rate because it usually causes either someone to pass out or go into a 4 or 5 minute coma if they're from Brazil and they have worked themselves into an estate tax issue, because very few countries on earth impose this kind of a tax rate on assets held at death. It's just not something that occurs internationally, but it's a huge issue here in the States because of the 40% rate. You get there, I can't remember. It's like you get there $3 after you have $3. You're at the 40% rate. It's like $12,000 bucks.
But it's also interesting that is actually historically low for the rate. It was 65% not too long ago at a certain threshold.
It was 65%. And the actual exemption was much smaller.
Right.
So it was a huge amount of work for estate planners. Now we just deal with very wealthy people because the exemption's so high, and we deal with a lot of foreign people who are not entitled to the exemption. I don't think we're going to go off on how U.S. citizenship works. It basically has to do with being born here or being born to U.S. citizen parents. But once you're a citizen, you're taxed on everything you own on Earth as part of the estate and gift tax. We'll get into later some of the credits you could get if you have assets in other countries. And we also could talk about expatriation if we have some time. One thing that is very confusing to most people is that estate and gift tax is based on domicile. So once you're domiciled in the U.S., you're subject to U.S. estate and gift tax. Domicile is like a state of mind, as if things weren't complicated enough, So domicile is like a state. you come here, you spend time here, and you intend to stay. How you prove intent? You know, there's all these factors. What have you done? Did you tell somebody you love it here and you're never leaving? You know, it's absolutely randomized. There's a number of cases on it, but you know, once you kind of intend to stay, and you die here, your assets held worldwide, even if you're not a citizen, are subject to U.S. estate tax. Interestingly, the income tax has nothing to do intrinsically with domicile. It's basically income you earn worldwide is subject to U.S. income tax based on presence. It's basically that it's come down to a formula. It's called the substantial presence test. It's based upon the fact that if you're here for any year for more than the year, you're subject to U.S. income tax, or if you're here for 3 years, there's a weighted determination which puts more weight on the current year and second current year, and then third current year has less weight in determining whether or not you're subject to U.S. income tax. Totally unrelated, really, to the estate and gift tax.
So it's possible to be a state tax resident.
That's
not
right,
need
and not an income tax. And how many times have we been in meetings, Brian, where someone will come in, they live here, and they've done their very best to not be subject to the substantial presence test. So there's what they call a cocktail party rule is if you're not here for 120 days a year, you're not subject to the U.S. income tax. So they can do all these formulas, whatever. The way it works out, if you're not here 120 days, you're not going to get caught by the U.S. Meanwhile, they have a condo here, and they want to stay, and they love it, and all the kids have moved here. The spouse has moved here, and you know we're definitely going to be here when we die. Well, now you're an estate and gift tax resident. You're not an income tax resident because you didn't satisfy the substantial.
Right.
But you're an estate tax resident. That's completely foreign concept to most people, right?
That's right. And the other interesting thing is it also offers planning opportunities.
Tremendous planning opportunities because you can play with the differences between the income tax and the estate and gift tax. Okay. We had mentioned the estate and gift on citizens and residents. It's imposed on worldwide assets. Both citizens and residents are entitled to the huge exemption, which may or may not be there, you know, in January, February, March. We're doing a lot of planning with respect to the fact that exemption the proposal on the Biden side is 5 million. It would go down to 5 million. But I mean, who knows what the actual end result is going to be. But for now, it's a very large exemption if you're a citizen or a resident. And the other factor we want to include in the slides is, you know, in terms of distinguishing between U.S. people, citizens, residents, and non-citizens, is this transfer between spouses. Those rules completely change with respect to the different classes of U.S. and non-U.S. people. And here it is, the spouses. So it's unlimited between spouses if you're U.S. to U.S. So U.S. citizen to U.S. citizen, there's no gift or estate tax, and then upon the death of the survivor, the estate tax hits, and hopefully we've done planning to keep that under that exemption, which you can amalgamate. You can have portability now, and you can add them both up, and you get the 23 million. If you're not a citizen, even if you're a resident and you're generally entitled to all the benefits of a citizen, you cannot get the marital deduction. You can't transfer between spouses if the recipient spouse is not a citizen unless you use a special trust. And guess what that trust does? It keeps the money in the U.S. So what was happening, I want to say it was the early 70s, before my time as a lawyer, was you'd have a U.S. person, and we had an unlimited marital deduction. The U.S. person and the resident non-citizen spouse would live. Let's say they were very wealthy. First spouse dies, money goes out. There's unlimited deduction, so there's no tax. And what happened was the non-citizen spouse hadn't done adequate planning and was facing a massive estate tax upon death. And, years ago, the gift exemption was also, there were years, prior to what, 94, was it? Where you're talking about $300,000 or $400,000. Well, it was not, it's $500,000, something like that. And some of these people, if you had tens of millions of dollars, you're talking about a massive part of your estate being subject to the estate tax. So they would leave. They would take all the assets, they'd sell the real estate, and they would go back to the country where they, usually where they retain citizenship, and the money be gone. So although that money was technically subject to U.S. estate and gift tax, this was before computers and exchanging of tax information between governments with any efficiency, it would be gone, and the IRS in particular would not have the opportunity to reach these millions that had exited the country. So the rule came in that you don't get the deduction if your surviving spouse is not a citizen unless you create a qualified domestic trust, which we call a QDOT, which it's a special trust that has a number of requirements, but generally it has a U.S. trustee, and the money stays here, so that when the second spouse to die goes, the money is taxed. That was a long-winded way of saying, if you think that one of the spouses is not going to be a citizen, you've got U.S. assets, you've got to do some serious planning. See here. Okay. Like we said, the citizens enjoy unlimited deduction for spousal gifts. If the spouse that survives is a U.S. person, it's okay. It's just if the spouse that survives is the non-U.S., that's when you run into problems. The same is true, we come across this with respect to gifts. So if your spouse is not a citizen, you can't just give away property to the non-citizen at no gift tax. You have to use up your exemption. You basically have to use up your exemption. Right now, it's a number that changes every year with inflation. Right now, it's about $150,000. And we have a note here in the slide. It doesn't matter where the survivor is domiciled. So the domicile, this residency issue does entitle both spouses to the exemption amount, but not between spouses. There's a note at the bottom, a general piece. A non-resident, non-citizen considering U.S. residency should make large spousal gifts because this ability to give spousal gifts, tax-free will go away once, basically, once they become U.S. residents. And of course, that's actually restricted as well. You'd actually have to plan around that as well, depending on the circumstances. But if you're considering coming in, we a lot of times have the non-resident, before they become a resident, make a lot of gifts outside the U.S. tax. And the general rule is outside the U.S. tax net, because I'm realizing that's kind of a broad statement.
Right.
Before you come in, that's the point.
And if it's in a trust, even more planning has to take place for a foreign trust.
Because then we have a 5-year
look back rule.
That's absolutely right. So here's the stark ugliness of the issue if you have a non-resident, non-citizen with property in the U.S.
Especially real estate. This is probably the most that we've seen.
Because it's hard to move it around. Yeah, and the real estate is U.S. Situs, right?
Right, and then so these non-resident, non-citizens from the UK or Brazil or wherever,
or somewhere that doesn't have a treaty,
right?
Yeah,
they'll buy a home here, or a condo, or a large place here, and you know, and then one of the spouses dies.
We had the Venezuelan group come in, and we were doing quite a bit of planning, but we didn't know because we weren't told. Their parents had come in. Their parents had come into the States. And what had happened was mom and dad bought a gargantuan mansion in a beautiful area in the middle of Florida. And they had bought it husband and wife. They didn't do any planning. By the way, they could have done a very simplistic planning and avoided the whole problem. They didn't do any planning. I think it was about $6 million, the mansion. And unexpectedly, mom died. Remember that even though dad may have inherited his half of that property, there's no free transfers between spouses. So half of the value, apart from 60,000, which is the extent of the exemption for non-residents, was taxed at a 40% rate. It's an unimaginable situation. It was unimaginable. It occurred. It occurs every day. Now, in our experience, a lot of this stuff is ignored, and some of it is not enforced. Not to the extent it's seen and not enforced. It's just the IRS doesn't pick up on it. It's a huge problem because such a small fraction of non-citizens coming into the U.S. are just buying property and seek any guidance at all. That was just an example that is a fairly recent example where it was just a tragic situation that was totally unnecessary. So that 13, well, let's call it 23 million between husband and wife exemption for citizens and residents goes away. Okay, so you have to be very, very careful with how you buy property if you're not a citizen and resident, because if you die with it, the tax is outrageous.
Or owning stock individually.
And the owning stock, a lot of times we can deal with that because it's an intangible asset, and we can move intangible assets free of tax out of the estate tax net. But if you die with it, same result. There's also a very odd treaty problem that occurs with stock that we'll hit when we get to the treaty slide here. You see here. The 15,000 is still applicable. They can give away 15,000 to different people. We had mentioned the intangible assets. Just as a little overview of intangible, because it's such a big factor where non-residents, non-citizens can give away intangible assets. What that means is like a contract right. You can give away these contract rights, stocks and companies, life insurance policies, these issues where you don't have a tangible asset. It's a piece of paper that represents something else. Even though currency is a piece of paper that represents something else, a judge said that gifts of currency are tangible if they're gifts in the U.S. Don't know how this has permeated its way through a number of areas of tax law, actually. Maybe Brian has a different position. I know Bowman would. If I had Bowman in here, he'd take a controversy. I mean, but it's currency is paper that represents something else. I don't know.
I think it goes to, tails I win for the government.
I don't know. So you got to be careful with currency because it's considered a tangible. Let me see how we're doing. We're doing fine on time. We've got 20 minutes or so. So unique asset considerations. Basically, these are things that even if you messed up all your planning and you moved here or you have assets here, there's some exemptions. Bank deposits are exempt from the estate tax if you die with them in the U.S. bank. So we've got 8,000 cases claiming the estate, the U.S. estate, claiming that the decedent had a bank deposit and it's not subject to U.S. estate tax. Well, what's a bank deposit? And so basically what's happened, because the government wants to tax it, is that a bank deposit really has to be like, you're talking about savings and loans, banks with a bank charter. If the money is sitting in Goldman, Merrill Lynch, um, or another brokerage house, you just lost 40% of the value if no planning occurred. It's a rough outcome, which can be avoided. I think in the next slide we show you how to avoid the whole thing, but just to keep in mind, it's more limited than it sounds. Portfolio debt is another exemption. A lot of times we can have foreign people make loans in to the U.S. There's a interest rate exception, that's an income tax issue, and then there's an exclusion from the state tax. You have to follow the rules. It has to have certain terms in it, this portfolio debt, and also government bonds and publicly traded bonds typically qualify as portfolio debt. And then life insurance, tremendous lobby, the life insurance groups. So you have a payout of life insurance. It's from a U.S. insurer. You insure the life of the non-resident, non-citizen. The payout is tax-free. So a lot of good planning too can occur with life insurance for non-resident, non-citizens.
But cash value is not exempt.
Yeah, cash value is not exempt. That's always a tricky one. You have to make sure that the non-resident is insured, and then what happens is you've got to deal with the cash value through a planning structure. Let me see here. Did I miss anything? No. Okay. So one exemption before we start the real planning are treaties. So a lot of times, if someone is a resident of the U.S. but not a citizen of the U.S., or a citizen of the U.S. resident in another country. So what the U.S. does in both situations is say, well, if you're a resident or a citizen, we're going to tax everything you own no matter where it's at, which is extremely onerous and almost always requires planning, both for U.S. and non-U.S. people, but especially non-U.S. people. Sometimes you can take a credit. So if you're taxed here and there, the U.S. will say, well, we'll give you a credit against tax you pay abroad. If you're a U.S. person, we'll give you credit against tax that you pay in another country. If you're a foreign person, we'll give you credit against U.S. tax that you pay as well. But we'll tax you on everything else. Those assets we'll give you a credit for. That's a lot of times based on Situs. Situs can be very tricky. So if the Situs rules, let's say you're a U.S. person, right, and you have stock in a country, let's say you have stock in a Singapore entity. Sometimes Singapore may say Situs, you may be holding those shares in Australia. Singapore says, okay, well, we won't tax you, but Australia will. But you're not a resident of Australia. You're a U.S. person, and the country, the U.S. may not give you credit. And so when we talk about Situs, sometimes it doesn't work. Sometimes it doesn't actually work, the actual foreign tax credit. Sometimes it doesn't even work with a treaty. So for instance, the next slide, the next term there is Situs treaties. So what that says is you may be a U.S. resident or citizen, and we're going to tax you on worldwide income. But you own stock in IBM, but your certificates are in, let's say they're back in Singapore. Singapore says, no, Situs of those stock certificates are in Singapore. We're going to tax you, right? U.S. says, no, it's a U.S. entity, so we're going to tax you. Now you have double taxation, right? So you'd think you'd be okay. But the definition of situs has changed. So the U.S. says, no, we don't recognize what Singapore calls situs. So the treaty might not even work. That's how complicated on a very scratch the surface level, even Brian shaking his head, even that's how on a very scratch the surface level, this double taxation issue can become, and domicile is, by the way, I didn't want to skip it, but domicile is a similar idea, which says you may be a citizen in one place, but domicile in another. If there's a treaty, the treaty says wherever you're domiciled, they will tax and nothing else. So if you're domiciled in the U.S. and you're a French national, the treaty says France won't tax you. Period. That's the modern style because of the wild complexity associated with the Situs treaties. The domicile are really the more modern treaties, which say, wherever you're at, that's who's going to tax you, estate tax wise. So what's the question? Where are you at? Now you've entered the net of whatever country you're resident. This is a list of some of the countries. So I thought some of you might want to take a quick look at which countries have signed which type treaties, which countries do Situs. You can see that the Situs treaties, maybe you can't see it. Yeah, you can't see it in the slide, but the Situs treaties are the older treaties that have been in place. The domicile treaties are the restatement of treaties, where we just kind of wanted, generally speaking, I think the people that negotiated these treaties wanted to kind of simplify things to wherever you're living, that's who is going to tax you. A lot of times, the treaties, people think that the treaties have permeated the earth. It's really not true. It's really not true. The treaty groups that negotiate these have a lot of trouble with negotiating treaties with South America, for instance. For whatever reason, there's not the confidence between the governments to negotiate these treaties. An interesting aspect of these negotiated issues is, let me skip one slide, I'll come right back, is tax exchange information agreements. And those are the countries that do tax information exchange. I wanted to skip a couple, I'll come right back to those slides, because even though there's no treaty, the countries share information. And so you have to be very careful. People who are irresponsible think that because they're putting cash or buying assets in different countries, that they won't be caught because it's not a treaty country. The treaties do have tax information exchange language. And then you have all of these exchange agreements. Look at all these countries. What they've done is the U.S. government has said, we're not going to allow certain deductions. It started with the Caribbean Basin Initiative and went from there. In our tax code, unless you sign these agreements, and every time an American does something in your country, you're going to tell us. I wanted to make that real clear and go back to these other slides. Because just by moving assets to these different, what you think are protective, confidential jurisdictions, may not be a great idea if you're not being prudent about it. That information is going to be shared. And now certain countries even share just everything. There's a stream on all information. If we want to really do planning, okay, with respect to non-citizen, non-residents in general, we want to shift assets. We want to create the ability of non-citizen, non-residents to invest in the U.S., but we don't want to subject them to the estate tax. And what's fantastic, and still exists, it's some of us wonder why this hasn't even been eliminated from the code, but hopefully it won't, knock on wood, is creating a foreign entity. You can create a foreign entity. That entity does not die. As long as it's taxed as a corporation, It's recognized by the U.S. as a foreign entity. When that foreign entity buys U.S. property, it becomes the taxpayer. So it creates a buffer between the death of the owner of the foreign corporation and the U.S. asset. And that's what we do. We create foreign corporations, or LLCs taxed as corporations. And that's what buys these U.S. assets, so that we don't get subjected to the U.S. estate and gift tax. There's some expense associated with it. It's not nearly as high as most people think. And amazingly, Brian can attest to this, amazingly, even the people that buy stuff here in a totally negligent way, most of them are kind of aware of that.
Yeah.
That they can create a foreign, but they just don't want to spend a little bit of money to create a foreign entity. It's absolutely nuts, given the estate tax. Other entities, wanted to touch base on the last few slides here before we have to wrap up. Other entities, you can do a foreign partnership, which may be a little bit better tax-wise. You just have to be careful, because the IRS has not opined that a foreign partnership is afforded that same barrier to the connection to the U.S. assets as a corporation. You'd think it would be, because it's an entity, and you can go through these rules associated with, is it an entity or not an entity? You can tailor the partnership. One major factor here is whether the partnership dissolves upon the death of a foreign owner. And if it does, the service will often just look through the partnership and say, no, that foreigner owns this U.S. property. We're going to impose a 40% tax on it. It's a little dangerous, the partnership. So we typically go LLC taxed as a corporation, and that will create a barrier between the foreign individual and the U.S. property. All right, let me see if I can find the next slide here. And that's what we mentioned here, the U.S. limited liability, elect corporate status. These are, it's just a drawing of Brian's body. So
Well,
are you on the left or the right? Okay.
I'm not sure. But wouldn't there be, from the perspective of planning, any non-resident, non-citizen, if they're going to buy U.S. real estate, should use a foreign corporation.
It's absolutely irresponsible not to do it. Also, with the real estate, Brian mentioned real estate because we can't get it out gift-wise for intangible as an intangible. You have the FIRPTA rules, which completely encumber the real estate. Just moving it, forget the tax and estate and gift and all that. Just moving it is such a hassle, because if you have gain on the property, it's considered a FIRPTA transaction. It could take 6 or 8 months just to get approval. So that's all avoided with the foreign entity. We talked about the treaties, the tax information exchange agreements. I didn't mention collection of tax abroad. That's a push. In other words, the U.S. may be so upset that you have that a U.S. resident or a U.S. citizen has bought property abroad or keeps it in a foreign account, that they try to collect the tax themselves. Sometimes the countries actually will allow the IRS into their country to handcuff whoever they need to handcuff to get that done. You have to be careful with that. We have a constitutional issue in the U.S., but they do allow collection of tax abroad. We're going to touch on, we have about 5 minutes left, foreign trusts, which is really a huge topic. Brian and I are working on a book on the taxation of foreign trusts. But there's a few things you can kind of keep in mind. Foreign trusts are highly protected for asset protection reasons. There's odd income tax rules that come into play, where I know we're doing estate and gift. If you have a U.S. individual and you have U.S. beneficiaries, typically U.S. people are creating the foreign trust, for instance, at the end of a financial transaction. We handle a lot of financial transactions, and they're getting a huge amount of money. They're subject to a massive indemnity, or there's some massive potential exposure that they're worried about. We create a foreign trust. Almost always in those situations, you have a U.S. beneficiary. In that case, you really haven't. You've created what's called a deemed grantor trust. For income tax purposes, it's really just that. It's really
disregarded, and it's probably an incomplete gift because they're a potential beneficiary
That's right.
the asset
That's right. On
protection
the
trust.
estate and gift side, it's probably an incomplete gift. You have to be careful with the completed gifts. In other words, if you use a foreign trust for estate planning purposes, it's kind of like an expatriation of cash. So when the cash goes out to a foreign trust, if you complete the gift, if it's out for estate and gift tax purposes, you have to be careful because when that grantor dies, there's an income tax. I know it sounds crazy because it's triggered on death. This is wildly complicated. But when that grantor dies, there's a tax which is on the gain associated with the mark-to-market tax, which comes into play.
The deemed sale. So it's the earlier of the U.S. grantor dies, or there's no more U.S. beneficiaries.
Yeah, or if there's no more U.S. beneficiaries. Typically, the grantor is a U.S. beneficiary. So when they die, so we have to be a little careful because if we don't do the completed gift, then upon death there is a state tax. Okay, typically we can domesticate back the foreign trust to avoid this, but there's an estate tax, but the assets get to step up in basis unless Joe Biden comes into office, but they generally get to step up in basis, and then there's no gain. So this income tax is not a threat. I know, slit your wrists. But you have to keep in mind that foreign trusts are taxed very differently, especially with U.S. people.
And then if you're a non-resident, non-citizen, and you want to do a pre-immigration style foreign trust before you come in, because you want to get your worldwide assets, non-U.S. assets outside the tax base before you come in. Exactly. And you don't want to make direct gifts to other non-resident, non-citizens, then a lot of times they'll want to prepare a foreign trust, which will be effective for estate and gift.
That's right. Fully effective for estate and gift. But the 5-year rule.
But the 5-year rule for income taxes, if their planning does not take place and they come here and they get their green card and they're domiciled here,
and they've come in before 5 years,
right? And they're here before 5 years. The income tax code says that it's a deemed transfer on the date you receive your residency. So you have a deemed sale of all those assets in that foreign trust on the date that they come to US.
If you don't have U.S. beneficiaries, it's a deemed sale. So it's a trap, basically. It's a trap. You've seen this a number of times. It's basically a trap. If you don't have an advisor.
And if you have U.S. bennies, it's delayed
until your death.
Your death, or you no longer have U.S. bennies.
Exactly. We're available for questions if any foreign tax issue comes up.
And then there are also a lot of, just on a side note, foreign trusts are very protective, and there are a lot of reasons to use them, be it from the U.S. side for asset protection reasons or for pre-immigration planning. But understand that there are reporting and compliance requirements that will be added on to
outrageous.
It's a lot
outrageous foreign.
But that's the cost of actually doing it.
Yeah, I mean that's obviously we've got the CPAs on the line. That's almost entirely done by CPAs, but it's substantial. And here's where we work through a number of the pieces we just walked through.
I think the main thing as relates to the estate and gift is just that be aware of the U.S. income tax rules when it relates to foreign trusts, because even though you might avoid estate and gift taxes, the income tax is still there, and it could be a trap for the unwary,
especially the non-resident, non-citizen. Yeah. What was happening is before all these rules, they've been enforced in one form or another for some time, but it's always the abuse that creates these rules. So you had a number of people. I remember when my career first started, people would come in, we couldn't obviously handle their work because they were criminals. But they would start these foreign trusts, and they'd get a credit card, and the credit card would be run through some jurisdiction, and this was escalated by volume, and then they couldn't police it. And so now we have this very complicated net of tax rules associated with assets transferred offshore for U.S. people to try to keep in mind that basically you haven't done much if you have a U.S. beneficiary. It's just basically grantor. We call grantor like disregarded for income tax purposes. And for foreign people, keep in mind this 5-year rule. So when we do pre-immigration, we get all the assets out of the U.S. tax net. there's a 5-year period you have to be careful of before you become a resident. And that's what we're talking about right there. And the last topic, which we have a few minutes for, is expatriation. One of the aspects of expatriation, that's when a citizen is no longer a citizen, but it also applies to long-term non-citizens. And that's where a lot of our work has come into play, because people who are here for 8 years under a green card are subject to these expatriation rules, which are very onerous. It's the same where it's not the asset moving out, it's the individual moving out. And that's this mark to market on that day. On that day, all of your assets are deemed sold, and the capital gains tax is due to the IRS. Brian, why don't you go through some of the exemptions?
Yeah, I mean, just, and it's interesting because not only do you have this exit tax if you fall into the net, and it's based on things like your net worth, which is $2 million, your average annual income tax liability for the previous 5 years, which is, I think it's indexed, it's $177,000 for 2020. Or if you even just fail to certify to the IRS that you're in compliance,
which is common.
It's very
which
common.
We mentioned that one because we found that a few times where people start to dabble in this. We involve an immigration lawyer also. It's not just you get a free pass if you're not highly wealthy or if you don't make a lot of income, but that free pass goes away if you don't do the full disclosure on all the IRS documentation. Very important.
And it's different. You have requirements for immigration. You have requirements for income tax. So they're totally different, and they have to both be complied with, because if not, they'll pull you into this net. And it's important because if you are pulled into this, any gift from then on for the non-resident, non-citizen to a U.S. beneficiary, it's a 40% tax on the gift.
Oh, it's outrageous.
Inheritance tax.
Yeah, it's outrageous.
And the donee pays the tax.
Well, there's two things that can happen. One is you didn't expatriate.
Right.
So you're still subject to the worldwide net.
Or
you expatriated and you've missed the second tax, which is the inheritance tax, which is what we're talking about back for transfers back into the U.S.
So if you expatriate, be it a long-term permanent resident or a U.S. citizen, and you're included in the 877A, exit tax, from then on, any transfers to a U.S. Benny, regardless if you acquired it even after you leave the U.S., they're going to pay the inheritance tax, which is under 2801. It's a transfer tax. It's under subtitle B, but it's unique because the donee pays the tax, not the donor, which is different than the gift tax.
Yeah, many countries impose that on the donee, but the U.S. does not. On the gift tax side, this is an oddity. Why? It goes back to the same idea. The IRS wants the assets here, and they want the people here. So the donee who receives the gift, by the way, this should never happen. This should never happen if there's any planning involved. Of course, that's the idea. There's no planning that happens, and then they grab the donee, the kid in school who you've given a gift to. But this is a very onerous tax with respect to people who have expatriated. That involves non-citizens as well, who end up giving gifts back to mostly children in the U.S. We've got a little over our time, and so they did, include a picture of me at the end. And let me go back to our contact information. Yeah, and so if you want a free book, we hope you enjoyed that at least. We realize it's confusing, but we're trying to raise some of the major issues. If you'd like a free book, my contact information in terms of the number and the email is there. Just email me your address, and I'd be happy to send you a free book. And I think that concludes our presentation for today. We hope you enjoyed it.
Gary, we have a couple questions. So let me just read this out. What are the tax traps for U.S. citizens relocating to Baja California or Costa Rica? And then the second part of that is, can you break down why some wealthy people give up their U.S. citizenship?
Well, relocation, so the other one would be expat, yeah.
So tax traps for U.S. citizens relocating to Baja California or Costa Rica?
Relocating is not a problem. Now, a lot of times this word expat is thrown around. If you're a U.S. citizen, for the expatriation rules to come into play, you actually have to give up your citizenship. Very, very few U.S. citizens give up their citizenship. Very few. It's a process, and they ask you if you're sure about 150 times before you give it up. What happens practically is that those rules were applied to non-citizens here for 8 years on a green card. That's the trap. They leave. They give up the green card because they don't want to pay, for other reasons, they don't want to pay U.S. income tax anymore. And they get trapped with the exit tax, the mark-to-market sale tax. U.S. citizens relocating are still subject to tax on worldwide income for the estate and gift. It doesn't change that. If you're not a huge earner, also what's nice is there's an income tax deduction because you're not really enjoying the roads and bridges in the US. That's the idea. So they give you a deduction if you earn income abroad. The other side of it is you have to be careful. Really the trap is if you enter as a resident another country, you stay there, you may become subject to their estate and gift tax regime, right? And there may not be a treaty, or there may not be a way to deal with it. So we would kind of work through what the facts. Where are you going? How long are you going to be there? Do you plan to stay permanently? We actually, in certain circumstances for very wealthy people, have to engage a tax lawyer in that country to make sure we're not stepping into some terrible problem. By the way, there are some really, really great opportunities for foreign people who we just come across from time to time. We're not experts in it because it's not our country. But for instance, we have a lot of Brazilian people that are taking up residence in Portugal. There's actually a tax holiday there. It's pretty exquisite, like some of the benefits. So in a nutshell, it doesn't change their situation. They just have to be careful with respect to the jurisdiction that they enter. You agree with that?
No, absolutely.
Okay. And then on the expatriation, what was the saying? I can't even read my own writing. What was the second question, Tony? Tony.
Okay, yes, I'm going to read that to you. Can you break down why some wealthy people want to give up the U.S. citizenship?
Oh, yeah, I'm sorry. Okay. What happens is if you're wealthy and you're looking at things, there was a real famous one, a guy who owned a cruise line, okay? And it works out such that if you die in the US, we can help you. We can reduce your taxable estate. But if you have $6 billion, there's going to be a taxable estate. I mean, it's very hard to get $6 billion out completely without having to pay a lot of estate or gift tax. So under certain circumstances, you may want to renounce your U.S. citizenship and go to a jurisdiction. Sometimes they have so much money, these people, I know this sounds crazy, that they actually negotiate an estate tax with the foreign jurisdiction. Okay? So you leave, you become a resident there, you're subject to their income tax, and you've either negotiated or they have a very small estate tax. And you save the $3 or $4 billion in U.S. estate tax. And that's one of the reasons that they put this mark-to-market rule in governing people who expatriate from the country. And that mark-to-market says, okay, you can leave, but you've got to pay the gain on everything that you own.
But a long-term capital gain right now is taxed at a lot
right,
lower
is a
level.
lower rate. Even now, you still may want to expatriate if you're super wealthy. That's right. Thanks so much, everyone.